Wills and Trusts, a quick and simple reference guide. Confused about the differences between wills and trusts? If so, you're not alone. While it's always wise to contact experts like us, it's also important to understand the basics. Here's a quick and simple reference guide. What living trusts can do that wills can't. Avoid a guardianship. A revocable living trust allows you to authorize your spouse, partner, child, or other trusted person to manage your assets should you become incapacitated and unable to manage your own affairs. Wills only become effective when you die, so they're useless in avoiding guardianship proceedings during your lifetime. Bypass probate. Property in a living trust does not pass through probate. Property that passes using a will guarantees probate. The probate process, designed to wrap up a person's affairs after satisfying their outstanding debt, is public and can be costly and time-consuming, sometimes taking years to resolve. Maintain privacy after death. Wills are public documents, but trusts are not. Anyone, including a neighbor, a predator, or an unscrupulous charity, can discover the details of your estate if you have a will. Trusts allow you to maintain your family's privacy after death. Protect you from a court challenge. Although court challenges to wills and trusts occur, attacking a trust is generally much harder than attacking a will because the trust provisions are not made public. What can a will do that revocable trusts can't? Name guardians. For children, only a will, not a living trust, nor any other type of document can be used to name guardians for minor children. Specify the personal representative of your estate. Wills allow you to name a personal representative to take responsibility to wrap up your estate after you die. This typically involves working with the probate court, protecting assets, paying your debts, and distributing what remains to beneficiaries. But if there are no assets in your probate estate because you have a fully funded trust, this feature is not necessarily useful. What can both wills and trusts do? Wills and trusts can be revisited and revised whenever your intentions or circumstances change, so long as you have the legal capacity to execute them. Warning: there is such a thing as irrevocable trusts, which can only be changed under certain circumstances using very specific methods. Name beneficiaries. Both will and trusts are vehicles which will allow you to name beneficiaries for your assets. Wills simply describe the assets and proclaim who gets what. Only assets in your individual names were controlled by a will. While trusts act similarly, you can also go one step further and transfer the property into a trust, commonly referred to as asset alignment or funding. Only assets in the name of your trust are controlled by your trust. Provide asset protection. Trusts, and less commonly wills, can be crafted to include protective subtrusts which allow your beneficiaries access, but keep the assets from being seized by their creditors, such as a divorcing spouse, car accident litigants, bankruptcy trustees, and business failures. While some of the differences between wills and trusts are subtle, others are not. Together, we'll take a look at your goals as well as your financial and family situation and design an estate plan tailored for your needs. Call us today and let's get started.